Alex here with part 22 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. In fact, my case is completely and totally closed. It's over. It cannot be reopened. My ex's parental rights have been terminated. Number two, in a nutshell, the purpose of the series is to provide my viewers with one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 21 with the filing of my reply to my ex's opposition for motion to order to show cause. This video is going to be a little interesting. I actually forgot all about this. What happened when I filed a request for submission on that particular briefing, and I'm talking about the show cause, so the efforts that I undertook to have my ex held in contempt of court. When I filed a request for submission, my ex's attorney had not responded to my motion. And the reason that she didn't do that is because she thought she still had another 3 days to file a response. She didn't. The reason that my ex's attorney was confused is because of what we call NRCP 6 subsection E. Subsection E of Rule 6 allows for an additional 3 days to file a response to a motion. In fact, it contemplates any sort of deadline. It's considered to be the computation of time rule. That's Rule 6. And subsection E is a specific subsection that allows 3 additional days to any computation based on the method used to serve whatever document it is that's being responded to. And in this case, I served that document personally. I went to my ex's law office and personally delivered it to her. Subsection E allows 3 additional days for mailing only under certain circumstances, and personal service is not included in that list of circumstances. In fact, if I remember correctly, I believe the rule has changed since then, but at the time the rule only allowed an additional 3 days if the document was served by mail. And my ex's attorney screwed up. She did not know, or she did not pay attention, or she wasn't used to being held to, the strict language of the rules. She was either winging it, didn't care, or she just wasn't used to being served personally. Maybe it was just something that didn't happen very often. And so either she personally or her staff assumed that she had an additional 3 days to file that opposition, and she didn't. So this video goes over her, quite frankly, panicked reaction to my having requested submission. What she did was file a motion to strike my request for submission, arguing that she should have been entitled to those additional 3 days under subsections, or under Rule 6 subsection E. And the logic that she uses in that motion to strike is ridiculous, and I'll go into that in a little bit when we actually get to her motion. But this does happen. Proper person litigants do sometimes catch attorneys off guard, and they end up panicking, trying to cover their tracks as to what went wrong. We're going to go into detail as to how she did that, and I suppose now is a better time than ever. So let's go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's motion to strike. This document is going to have a few areas that are a little bit off, and I think it's a strong indicator that the document was prepared a little bit haphazardly, a little frantically, and I'm going to try to point those out to the viewers when I see them. But the very first one I saw right away, here in the first paragraph, the attorney identifies the litigant, identifies herself, and identifies the document, but the document identified is a motion to enlarge time to allow consideration of opposition filed. But what she's actually filing is a motion to strike. So just a little off there. The court's not really going to care. The court's going to know what she was talking about. But I wanted to point this out to the viewers because there are other areas in this document where I noticed similar mistakes. So we're going to scroll down. We have here the points and authorities. This was supposed to be broken down into the factual background and the argument. It looks like she intended to do that because if you look down a little bit, you can see here that she identifies section 2 as the argument, but she forgets to identify section 1. And again, I'm only pointing these little details out to show viewers that sometimes attorneys make mistakes and they also will react, much like we do, in a panic state, frantically to correct those mistakes. And it shows in the documents when they do this. Here she is identifying in the first paragraph what I filed, the first paragraph of this page. The first paragraph of this page, she identifies that I filed a motion for order to show cause. The opposition she indicates would have been due on January 12th. Now later on in this document, she plays dumb, and we'll point that out when we get to it. But going down to paragraph 2, we see that she filed her opposition or attempted to file it on January 7th. But it was rejected because she did not include the necessary affirmation. I talked about this in previous videos. This happens to non-attorneys all the time. We don't know what's required, so we forget to put stuff into our documents, and we get sent away, sent back, back to the self-help center or whatever. And this happens to attorneys too. They sometimes will have, they'll make mistakes, they'll forget to include things that are required by law, and their documents will also get rejected. And I think it's nice for the viewers to see that this happens to attorneys just as much as it happens to us. Scrolling a little bit further down, she indicates that once she realized it was rejected, she attempted to refile it. These exhibits here that are being referenced are attached to this motion. We're going to go through them in a lot more detail when we actually get to them, but for now we're just going to take everything as granted, as true. And like I said, we'll get down to those in a second. In my reply, I'm contending that she filed her opposition late, because she did. She did file it late, and she knows she did. But she can't admit that to the court, because that would be, oh my God, that would be so bad. If she admitted she made this mistake, she could be subjected to disciplinary proceedings. She could be subjected to, what do they call it, attorney malpractice. They have another name for this, litigation malpractice, which would destroy her insurance premiums. They would skyrocket. So she can't admit this. She has to find some plausible explanation. It's better to come off as negligent than it is to come off as incompetent. With respect to negligence, it's oops, I made a mistake, I wasn't paying attention. Whereas with incompetence, it's I thought this is how the rule read and I was just wrong, and now I'm suffering the consequences for being wrong. So here she is saying that Rule 6E applies. I talked a bit about this a little bit earlier in the video. Rule 6E gives an additional 3 days only when the document was served by mail. And here she indicates that it does apply only when the document is served by mail or electronic means. Now, electronic means at the date that this was filed was not available to non-attorneys. So I don't know what she's talking about exactly at this point in time. I think that she is enrolled with some kind of program that only attorneys have access to. I don't know what the name of it is, but she's enrolled in some kind of program. I know that attorneys had to pay like a $300 fee per year to be enrolled in that program. And it's a program that allows them the ability to download documents filed in cases. And it's also a program that lets them know when documents were filed in certain cases. So she is trying to play dumb. She's trying to say that the notification that she got from this program she was enrolled in counts as electronic service, which is so obviously wrong. But that's what she has to do. She has to have some kind of plausible explanation as to how this happened. And the explanation that does the least amount of damage to her and her practice is the one that she's going to go with. So in this case, she's saying, hey, I was served, which isn't true because it's not service of process. She was notified is what happened. She was notified electronically by that program that she was enrolled in, and because she was notified electronically, she is entitled to an additional 3 days. And as I mentioned, non-attorneys, we don't even have any access to this program. And if what she was saying was true, it would be an exploit. It would be unfair, because attorneys who were enrolled in the system would always get an additional 3 days no matter what. They may as well not even count Rule 6E. They may as well just say, hey, if you sign up for this system, you just always get three extra days because this system will always notify you electronically. She doesn't lie about being personally served. She indicates that she was served. Let's take a quick look here. Right, in the next paragraph, she admits that I served her both personally and by e-filing. So she's not lying. She's telling the truth. And she's just saying that because she was served both personally and by e-filing. And of course, I mentioned earlier, that's not service, that's just notification. And also, this is misleading because I didn't e-file this document. As I mentioned earlier, non-attorneys couldn't file things electronically at that time. Later on, we do gain access to a system. I think it happened around 2014. But at this point in time, non-attorneys could not e-file documents. But she's claiming that since she was served with both, she should get that extra 3 days. And apparently that is different than being just personally served. But of course, this is just what they have to do to defend themselves. I talk about this in the video. They will never say good things. They're not going to just admit they were wrong and ask to be punished. They're going to have to come up with some kind of plausible explanation for what happened, even if it's not true. As long as it's plausible, sometimes they'll get away with it. So scrolling down, even if the court looks at January 7th as the date that it should have been filed, they made an attempt to do so and they shouldn't be punished for it. I feel like this would have been the better approach. I think it makes her look bad to try to claim that I served her electronically and they should get an additional 3 days for mailing. And honestly, it does make the attorney look bad. It makes them look like they're playing dumb, like they're trying to deceive the court. She should have just claimed that she tried to serve it on the 7th and it was rejected, and so she had no choice but to serve it on the 8th. But I suspect that the reason she did not do this is because there may be 2 reasons. The first reason is she may have not gotten notification of the rejection until the next day. That's possible, and I think that may be true. We'll take a look at that when we get down to the exhibits. The second thing is that she would want to have more defenses available to her on appeal, and if the judge did rule against her, she would want to have those 2 different bases to appeal on rather than just the one. But again, I really don't think the Supreme Court would have bought that for even a second. They would have just quickly swept that aside. That argument was totally meritless. Let's scroll on down here. Section B, enlargement of time to respond is proper. Now, it sounds like she's asking the court observed that the purpose of each rule is remedial and its object is to relieve litigants who, through some inadvertence, such as is common to mankind, might be deprived of a hearing upon the merits through their unintentional failure to bring themselves within a rule. So she's basically saying that the harshness of rigid application of the rules can hurt a person, which is true. This is true. And like I said earlier, these rules do favor her. And if she's 1 day late and she has a reason for it, that's understandable. I just think that the defense that NRCP 6E should apply is egregious and way out of boundaries. But this defense here that she made a mistake is, in my opinion, a lot more reasonable approach and doesn't make her look as bad. We'll continue scrolling down here. If she properly filed her opposition, the court should accept that filing and consider it in deciding the plaintiff's motion. So I'm not sure why she's asking for an extension of time, because she files it on the, maybe she's just playing, she's playing it safe. Maybe just, 1 extra basis to appeal. She could argue that she was entitled to an extension or an enlargement of time. So in this case, she has preserved 3 different arguments on appeal. 2 of them are an absolute joke. But one of them is a good argument, and that is the excusable neglect for having made a mistake, especially when it comes to domestic domestic relations matters? Yes, domestic relations matters, which includes child custody actions. In these types of cases, they do like to give you some leeway and rule on the merits of the cases because it will impact children. And so I really feel like that's all she really needed. That was the best argument, and I myself would have understood that and been like, all right, it's fine, you were a day late, no big deal. But the other 2, the one where she's trying to say she should get an enlargement of time, you can't ask for that after you're already late. That's just wrong. There's case law on that forbids doing that. And then the other one trying to say NRCP 6E applies when she gets a notification through her attorney system, which would, that just has so many things that are wrong with it. I won't even go into it. I'm not even sure that I filed an opposition to this motion. I believe that what I did was just file my reply immediately after receiving this opposition, and that was that. And so it'll be interesting to see if I did file an opposition to this motion. I don't think I did, but I might have. And if so, it'll be interesting to see my analysis on opposition. But let's take a look. Down here, we see the affirmation. And look here, she's using a custom affirmation. She's not using that self-help page, which is good. That's less paper. Certificate of mailing, she's indicating that she mailed this to me, which is allowed under Rule 5, which is good. That's my address right there. Well, at the time, It's not anymore. That's my really, really old address from 2009. Here is the motion opposition notice. We've talked about this several times. You fill in the check boxes and you'll determine whether or not you have to pay a $25 filing fee. In this case, she did not have to pay that fee. The index of exhibits, I've mentioned before, this is required. If you do not include this, your document will be rejected for sure. So check with your jurisdiction. Anytime you're about to go file a document with exhibits, make sure you include this if it's required, because if not, you will be sent away. Oh, let me take a quick look at these. So we have the email notice, and we have 2 rejections, a received, an affidavit, and another notice. This is probably just communication between the attorney and that program that she signed up for. Scroll down. Exhibit 1 divider. Again, this is required. If you just stack your exhibits back to back, they will be the document will be rejected. You will be sent back. You will be sent away. So for all of you out there who are prepared to file documents on your own, make sure you look into those rules, because if you need to include these separation pages and you do not do so, you're going to end up having to make a second trip to the courthouse. Sorry about that. Tongue twister there. Next page is notification of e-filing. Hey, this is the same program we use now. Okay, so apparently the program that we use now, non-attorneys can sign up for this now. So this was not available to us back in 2009. Only attorneys could use this program. This is the same system that we non-attorneys can use now. They must have opened it up to non-attorneys. Okay, so I thought they created a new system, but they didn't. What they did was allow us access to the existing system that was in place for attorneys prior. So this is, I'm used to seeing these. As soon as we were required to sign up in 2013, 2014, somewhere around there, as soon as we were required to sign up for this system, we started to sign up and we started to gain access to electronic filings as well. But even then, personal service is still personal service. This is not a, what do they call it? This does not supersede personal service. This is just a courtesy notice from the program. In fact, I think later on, they had something called consent to electronic service that you could sign up for if you wanted to. And anyway, these are details that I don't need to get into because the document was personally served anyway, but I did want to mention to my viewers that I know what this is now that I've seen it. So this here is a notification to the attorney that this document was filed by me. And here it's just letting know that she was electronically notified. Proper person. Oh, I thought it was mentioning my channel, which is impossible because my channel didn't exist at the time. But this is just saying that I'm a self-represented party and that I have to be notified by mail. This doesn't make any sense because I filed this document, so you don't need to notify the person who filed the document because they know that the document was filed because they're the ones who filed it. Exhibit 2. This is a rejection notice. The document was rejected. Wait, no. This is not a rejection notice. This is a received. Okay, so this is the notice that she filed her opposition and it was received by the electronic system. Okay, so the first notice was her notification of my filing. This notice is her notification of her own filing. Exhibit 3. This is the notification of the rejection of her filing. So she's including this to let the court know that she tried to file it on, let me scroll back up for a second. She tried to file it on the 7th of July, as she indicated. And she was notified that it was rejected on the 8th. I said July, didn't I? On the 7th of January. She then was notified on the 8th of January that it was rejected. Okay, so this is a good explanation. She really didn't need to rely on Rule 6E. She really had a good explanation for why, she's late. She filed it on time on the 7th, and then on the 8th, it was rejected, and so she filed it late, but she can show the court that that was on accident. She didn't mean to file it late. She didn't need to rely on those other arguments. I think it wouldn't have come off so bad if she didn't do that. In fact, this video wouldn't be such a big deal because I would have just said, hey, she claimed excusable neglect, and in child custody actions, it's a domestic relations matter, and the courts want to reach these decisions on the merits, and they're of course going to take a late filing when she tried to file it on time. Even if she didn't, even if she just forgot and filed it late, they would still, I think, take her opposition. And Yeah, I just think it was unnecessary to use NRCP 6E. So we got Exhibit 4 here. This is the... So this shows that she tried to file her opposition again on the 8th. And this here is the affidavit of the employee. Well, let's see what he's saying here. He was instructed on January 7th to file the opposition. He scanned the document so that it would be submitted. He scanned the opposition into the system. He received an automated response from the system. He arrived at the law office and realized that the document... He's just saying he logged into a system. He received a notification that it was rejected due to the missing information. He immediately placed an affirmation with Ms. Berning's signature in the correct location, which is good. He received an automatic notification that it was filed by the court. Okay. And he received a proof of service from the e-filing. Okay, so he got the proof of service on January 8th, and then he delivered a file stamped copy of the request for submission to the law office. Well, he's over, that's, okay, I get it. So he's just basically saying that he's just going through the steps, that's all. It's just an extra precaution, I guess, by the attorney to make sure that this affidavit was filed so that the court could really see that it was excusable neglect. Scrolling down here, we have Exhibit 6, and this indicates that my request for submission was filed. Yeah, request for submission. I did double check there, it was a little confusing. Going into the aftermath, I filed nothing in this particular video, so I incurred $0 in costs. My ex filed the motion to strike. However, based on the motion opposition notice, she didn't have to pay a filing fee, and she served it by mail. That's just going to cost a postage stamp, so I'm not going to really include that in our numbers, so she incurred $0 in costs as well. I didn't have an attorney at the time, so I incurred $0 in attorney fees. My ex's attorney probably charged her for this, but I can't say for sure because sometimes attorneys will do work for free when they feel like it's their fault. And so what I'm going to do is imagine how much she would have charged and half it, just in case she didn't charge anything at all, because we just aren't sure if it was done for free or if she charged. So if she would have charged for this, I think it would have taken her about 1 hour minimum to prepare, just because it is totally custom. There is nothing in that form that is a fill in the blank or check boxes or anything like that. So it's got also 5 or 6 different exhibits. You know, that time adds up to at least an hour, I think. And so she would have charged her $250 an hour, so 1 hour, that would be $250 in attorney fees. But there is a possibility that she did it for free because she might feel like it was her fault that she had to do it. So between $0 and $250, we're going to split the difference because we just don't know if it was billed. And we're going to put this one in for $125 in attorney fees for my ex. So if anyone has any questions, definitely feel free to post something down in the comments below. You can also email me at admin@theproperperson.com. Usually after this point, you will see a black screen with some of the end screen notations pop up. But in this case, I'm starting to put together a little collage of the viewers who are supporting this channel financially through membership. And I just wanted to mention that I really do appreciate what you guys are doing. A couple of bucks goes a long way. And so I'm going to try to include everyone's, logo or everyone's face. Depending on what's in your YouTube profile, I'm not going to hunt down your pictures. I'll include that from now on in the end screen. And if any of you guys are wondering how to go about doing that yourselves, you can look at the videos, channel memberships, or you can look at the videos. I think it's levels or possibly membership levels, something like that. So I will definitely see you guys next time, and I appreciate all of you.